Good afternoon, everyone. Good to see you all, and lunch is coming soon. Do not fear. But before then, you have to listen to our wonderful panelists, and we're going to talk about securities class actions in the United States and also globally. And we have really an august panel here. To my immediate left is Matt Kane. Matt is handling a number of, he's the foremost economic and damages analyst in shareholder litigation and other consumer and commercial litigations. He's currently serving as an expert in the Credit Suisse case, which we'll talk about a little later, in the Densply case as well, and numerous other cases throughout the United States, and I understand internationally as well. So it's good to have you here, Matt. To Matt's left is the venerable Roger Cooper, head of Securities Litigation Department at Cleary Gottlieb. Roger has served as lead defense counsel for defendants in the Petrobras class action, Allergan, and those are Densply as well. Petrobras and Allergan, he squared off against Pomerantz in those cases. And Petrobras, we settled the case for $3 billion. Commentators say that because of Roger, without Roger, it would have settled for $6 billion. So, yeah, you shouldn't think any less of him because it was a $3 billion. It was actually his great work that made it only $3 billion. And then to Roger's immediate left is Carol Gilden, my colleague in the plaintiff's bar. And Carol is really a superstar in the securities class action space. She's a leader in the in our actions and our work that we do with regulators and Congress, making sure that plaintiffs' voices are heard with respect to shareholder litigation, and investors are properly protected. And she's settled hundreds of millions of dollars worth of settlements in the U.S. In various litigations throughout the country. And so it's really a pleasure to have you all here. Thank you for coming. And we'll kick off, really, you should all know, is that the new administration, I remember saying to myself the first few months after hearing of Independence Day and all the great announcements that came out of the administration, I said to myself, maybe it was April or May, and I said, wow, it's really surprising that my practice wasn't impacted by all this political upheaval. And so I remember, I was thinking that to myself, but then, that seems to be very fleeting thoughts and realities. And so there have been a number of key changes in the U.S., really politically by the administration. We'll talk about in Delaware. And these are potentially, we don't know really the impacts of these changes, but they're definitely potentially seismic. And so let's talk about, the first change is the SEC has come out with a new change in policy. Previously, the SEC had said that if anyone had a mandatory arbitration bylaw or clause in its registration documents, that company essentially would not be able to go public. They would not go for, their IPO would not be accelerated. Now, the SEC Chair Atkins has come out and said, that is no longer the policy. We will no longer have any barrier if a company, a corporation, has an SEC mandatory arbitration bylaw. And it's important to understand it's not just about arbitration. The bylaw can say that you have to arbitrate and you cannot do a class action. So essentially, a corporation could have a bylaw that says essentially no class actions, and you waive your right to a class action. And now the SEC chair, and mind you, the SEC's mandate is to protect investors. It's supposed to be to protect shareholders. And he's come out and said, well, we're not going to stop corporations from having these bylaws. We're going to allow them to register. Not only that, he went and spoke a few weeks later to a symposium in Delaware. Delaware itself has a corporate law that says you cannot have these bylaws, and that it's against Delaware corporate law. And he vocally and explicitly, pressed Delaware legislators to change the rules in Delaware to allow for these mandatory arbitration provisions. All that to say is that you have the SEC chair openly encouraging corporations to skirt class actions and to put in bylaws that stop them from having class actions and really giving a pass to these corporations. So that's new information. That's new, a very sharp reversal by the chairman of the SEC, whose job it is to protect shareholders. And so really that's an important event and potentially very bad for class actions in the United States. And so Carol, what do you think of these changes? What are the impacts? And what we can do about it?
Sure. Well, thank you, Jeremy. And let me just say, sort of to begin, I did start my career as an enforcement attorney with the Securities and Exchange Commission. So I look at, I think heretofore at the agency as a way to protect investors. This is really a change that I think you would agree, Jeremy, just stands the role of the SEC on its head. The potential impact for investors is quite serious. The potential impact on the integrity of our capital markets is also quite serious. When companies come to the U.S. markets, they come to the U.S. markets in part to obviously raise capital, and it's quite well established that companies obtain a premium on the value of their securities. Investors look to the markets and they know that they have the backing of the federal securities laws and heretofore up till now, the SEC as a means to provide accountability when companies step out and commit fraud. If companies start enacting these provisions, what will happen? It's really opening, for lack of a better phrase, Pandora's box. From a company's standpoint, and I'll be interested to hear Roger's comments, from a company's standpoint, they face the risk, if they enact these provisions, of facing hundreds of potential arbitrations. It would be very inefficient from a company's standpoint, but worse, from an investor's standpoint, it really sort of is a very inequitable result for investors. You have large investors with substantial losses who have the means, both the capital and the access to lawyers and the sophistication to know if they have been defrauded, well, they'll go into arbitration. So on the one hand, you potentially could have hundreds of lawsuits, obviously very inefficient. Moreover, you would lose the value of the rule of law, of standards, of guidelines, of what is acceptable corporate behavior, what is acceptable corporate disclosures, because there are no rules of law, in a sense, that apply when one goes into arbitration. Different arbitrators may rule differently, and there's no means to ensure accountability. In contrast, the beauty and the whole premise of a class action is that it allows the same group of individuals or companies or entities, in this case investors, to have their claims litigated in one forum with a uniform body of law that applies. And so I think what will result will be very haphazard litigation, very inefficient litigation, a lack of standards. In addition, companies will also lose the benefit of one of the things that the Private Securities Litigation Reform Act provides, which is a high pleading standard. Now you asked about things that we can do. And so a group of very large number of institutional investors signed a letter to Chairman Atkins. These institutional investors represent over $8 trillion in assets under management. And they implored the chair and the SEC to go back to the standards that have heretofore existed for decades in terms of allowing lawsuits to go forward. So, it is a very serious potential change. It really will wreak havoc to the extent that companies do sort of take up the battle. And I think it will also result in a lot of legal challenges, both on a constitutional basis as well on a state law basis. So I could continue, but I'm sure Roger has his own perspective.
Roger, give us your take. Are you advising your clients to employ these provisions? Is this the end of securities litigation as we know it?
So I think there are some folks out there who may believe that this could be the end of securities litigation, class action litigation as we know it. But I share Carol's sort of skepticism as to whether this is a good move from, I'm going to say, from a defense perspective, but I think I do share your view that there are some real downsides to this. I think you've described well what could happen, right? If you no longer, if you have an arbitration requirement and you can only bring individual arbitrations, I think it's not just hundreds of claims, but potentially thousands of claims, each of which you have to litigate or arbitrate separately. You know, one of the great things, important things about Rule 23 and the class action, opt-out class action mechanism for defendants is that is a way to also resolve claims, right, all claims against the defendants and to get global peace that you can settle on a class-wide basis under Rule 23 and that anyone who's within the definition of the class gives a release and you're finished. But if you are forcing investors to arbitrate, you just can have one after the other, right? So there's no way, there's not an MDL structure, there's no structure to consolidate these cases and to figure out a way to resolve all of them and understand, right, what is going to be the overall exposure when you decide to resolve them. So I think that's one issue. The PSLRA obviously is another huge issue, which you mentioned. This is the 30th year of the PSLRA, which was adopted in '95. Which gave
Happy
a lot
anniversary.
of exactly, yeah. Well, it gave a lot of protections to defendants, not just the pleading standard, but the stay of discovery, and a motion to dismiss. Right? It's not clear you get any opportunity to dismiss a pleading in an arbitration. I don't think so. At least that's not standard. And so it means you're gonna go to trial on each of these claims, and so those procedural protections are going to be gone. And Jeremy and I were discussing this earlier. I mean, the other issue is for at least Section 11 claims, so claims for a new offering of securities. You know, the statute provides that you can sue directors, you can sue underwriters, you can sue auditors, and I don't think an arbitration clause can require that the claims against those other parties, those statutory parties, need to be arbitrated. So I think an issuer could find itself arbitrating claims against itself and then litigating in federal court claims that are brought against the underwriters, auditors, directors, and the company indemnifies those folks, at least the underwriters and the directors, and it's going to be brought into that litigation because that has all the documents. So even if it's not named a defendant, it's basically going to be paying for and litigating on multiple fronts. So that doesn't sound like the kind of efficient approach that a company wants to be in. So I think you need to be really cautious here. Now, I think some folks believe that that a company could be fairly creative in crafting the arbitration clause and sort of deal with some of these issues and build in some protections. So let's see, but I'm not convinced yet that is going to happen. As far as I know, no company has done this, but while Delaware prohibits it right now under DGCL 115, and this is the irony, is this change was just passed in April or May of this year, before anyone anticipated that this was going to come about, but Delaware just made this change that would prohibit having an mandatory arbitration clause for Delaware company. But if you're in Texas, you could go ahead. So we could see a company IPOing incorporated in Texas and testing what this looks like.
Matt, if a corporation does not follow Roger's advice and puts in this arbitration clause and incorporates in Texas, how would you see doing a damages model in an individual arbitration? How might it differ from the way you're doing it now? Could we make a little more money maybe in an arbitration? What do you think?
Yeah, you know, I think I would echo what Roger and Carol were saying. From my perspective as an expert, when you talk about it potentially increasing the cost of litigating, part of that cost is paying for expert testimony and the work that we do. So I agree that raises the potential for more work, more expert work. I've worked on many class actions. I've also worked on opt-out cases. The work that we do is not really that different for one large institutional investor versus a class of investors. Maybe we skip over a little bit in terms of the reliance element and market efficiency. If you've got individual investors who can explicitly state that they relied on misrepresentations as opposed to just the stock price itself. But beyond that, I think it's still largely the same degree of work, assessing price impact, running event studies, looking at the stock price impacts, direct calculations of damages using the trading records of the individual investors as opposed to modeling those estimates at a class level. But in terms of the work for the expert, I think it's all very similar and potentially multiplied across a number of individual cases as opposed to just doing it once for the entire class.
So you could bill each case. It would be
Potentially
to you,
bill
then.
multiple. Yeah.
You're gonna
Yes.
have to testify in every arbitration, each of
There
the
you go.
arbitration
There you
hearings.
go. So we may need many more experts, right? So
I think also, over the past 30 years, but even more in the past 15 years, 20 years, defendants have done a very good job in limiting damages, requiring statistical significance, saying it only has to be sometimes, it should only be 95%, whether it's 90%. You only get the 1 or 2 day drops right after the disclosure of negative information. That's really limited damages. In the old days, in the freewheeling days of where Torkelson was the favorite expert of the plaintiff's bar, and he would just look at the stock chart and say, well, damages are the stock was at 98 and now it's at 0, so your inflation was $98. And I think I could see that now being, if there's an individual arbitration, I would definitely encourage arbitrators and experts to take a fresh look at that, because I think a lot of losses and damages really are ignored and hidden. I think really the way you should look at losses and damages are, how did this stock perform compared to the market generally over the class period, or at least when the corrective disclosures started to come out, and can you attribute any other reason why the stock went down other than the negative news that came to the market? And unfortunately, that's, now it's become, well, you have this 1 or 2 day window, and there can't be any confounding information that impacts the stock, so you're really, really limited. And I think the arbitrations might open up, if it goes to that, and let's hope it doesn't. We don't want it either. I think that could really, arbitrators might take a fresh look at that type of issue. So I think that's something that, could be, and again, further risk. And to Roger's point that, the advantage now you have in federal securities class actions is the path is very well trodden. You kind of know cases filed, gets through motion to dismiss. You can probably go to a board and tell them what the exposure is, what the likely range of losses are, what it should settle at, what it likely will settle at. And I think you get into these mass arbitrations, and I think it becomes just a Wild West again. Is it good for plaintiffs? No. But I think we'll adapt. There's a lot of claims filers out there and claims administrators who probably know how to get to the clients and how to reach out to them and to sign them up. And so all of a sudden this becomes another cottage industry that could be quite costly for, I think, all involved. So, I think, to the extent that, Roger, if you are advising your clients not to adopt these provisions, I don't want to I don't want to be a fly on the wall of how you advise your clients, but I think that's, probably be good advice.
It's almost the adage of be careful of what you wish for.
100%,
Yes.
100%.
Yes.
People forget that actually,
Right.
Rule 23 was quote unquote bipartisan, i.e. both plaintiffs and defendants thought it was a good idea. They wanted to get everyone in one courthouse, final adjudication, final global peace. That's a good thing. So then all of a sudden it became too successful, and there's $200 billion have been collected since 1995. And then some people say, well, hey, wait a minute. But you be careful what you wish for. As
Jeremy, one other point I would also add is if you're a carrier, an insurance carrier, I cannot imagine that they're going to welcome the prospect of a multitude, and I think you're right, more than hundreds, you're talking thousands, of suits and having to defend the companies. And then on the other hand, your officers, your managers, they're going to be deposed and subject to testimony again and again and again and again. Again, certainly very, very disruptive by any stretch of the imagination, and not good for anyone. And I will say one other thing, Jeremy. We are seeing in other venues arbitration creeping in, and where firms are now starting somewhat akin to what we see in the mass torts area, the grouping of claims, similar to opt-outs, which both our firms do, as well, but on a much larger scale. So models do exist to handle, from different areas, huge numbers of claims and to advance those claims.
Yeah, 100%. Well, in further news, and again, further disruptive news, Delaware, around March of this year, after there was a ruling in the Delaware Chancery Court repealing Elon Musk's $56 billion pay package, and he was pretty upset, and a lot of defendants and corporations were upset about that, and then there was threats of a Dexit. We're going to get out of Delaware, we're going to go en masse to Nevada and Texas, where it's much more liberal ground for executives to do what they want to do as far as compensation and as far as less challenges and less access to books and records. And so in this fear of Dexit, without any kind of warning, without any comment period, the Delaware legislature passed S-121, which really made certain changes to Delaware corporate law, made these types of cases that were against controlling shareholders harder to bring, access to books and records more difficult to get. And Elon Musk said, well, if I can't get $56 billion, I'm definitely entitled to $1 trillion. And so now in Texas, he's trying to get a $1 trillion pay package passed. But Roger, maybe you could take us through some of these changes that have been made, what the impacts are, how much of a change is it really, and we could talk about it.
Yeah, I mean, this is also a story of uncertainty and lack of predictability, or claimed uncertainty, claimed lack of predictability in the way the Court of Chancery was ruling in certain cases that were brought before it that involved conflicts or controllers or take private transactions. And there was a perception that was increasingly public and vocal that the Court of Chancery had swung too far in favor of shareholders' interests and was too skeptical, too critical of particularly controlled companies. And that was coming from Elon Musk. It was coming from Mark Zuckerberg. I think he went public and made a statement maybe that Meta would go to Texas in probably February of this year. And very quickly then, the Delaware legislature brought forth SB 21, which was passed and signed into law at the end of March, as Jeremy said. So it did a few things. The first change that it put into effect. And just like big picture, we're talking about Delaware law now. Usually when we talk about securities cases, we're talking about federal disclosure law, but Delaware is, it's fiduciary duty, there's what kind of the kinds of claims are fiduciary duty claims. Some of them are class action claims that would be at issue here. Others are derivative claims brought on behalf of the company for harm to the company. So the first big piece was that it put in place 3 safe harbors for different categories of board actions or decisions or transactions, M&A transactions. So where their board members are interested in the action or decision, or there's conflicts at the board, it sets out a process for providing a safe harbor for those decisions. Similarly, where there's a controller that is involved in the transaction, again, a safe harbor, which would either you can use a special committee or get a vote of the majority of the minority stockholders. And then also a third safe harbor for take private transactions involving a controlling stockholder. And the basic idea is it's a recipe, and if the company and the board follow what's set out in the statute, then you're entitled to a safe harbor that would prohibit anyone from bringing claims for damages or for equitable relief against the board related to that board action or transaction. It also, to sort of address this question of uncertainty, it provides some definitions that apply for these safe harbors. So one is a presumption of independence of the directors who are on the special committee when the board determines that they're independent under NASDAQ or New York Stock Exchange rules. And that's just a presumption, so it can be rebutted, but it's a very high standard, and a plaintiff has to come forward with a kind of detailed evidence to challenge that presumption. It also provides a more precise definition of what is a controller or a controlling stockholder, a control group, and this has been something in the law now for the last 5 or so years or more. That's been hotly contested, right? Do you have to own 51%, 50 plus percent of the company? Elon Musk was deemed a controller, even though I think he had 20-some% of Tesla, just because of his influence at the board. And so there was kind of a question like, geez, can anyone be a controller? Who's a controller? So now it lays out a formula for who's a controller, controlling stockholder. And then there's a few other definitions that kind of clarify things. And then the last piece is that it provides some limitations on books and records, which a stockholder is entitled to get from a Delaware company to investigate, if there's been some kind of wrongdoing. And so I think Carol's going to talk about that. Should I talk about because right now there's litigation going on at the Delaware Supreme Court as to whether SB 21 is actually constitutional.
Carol, why don't you address it, and then Roger, you can talk about the constitutional challenges.
Sure. So in terms of the books and records, and sort of the level set here, books and records are generally used to establish demand futility, and they're considered by the Chancery Court as sort of using the tools in hand. So for those of you who are not familiar with what we're talking about in terms of books and records, as a shareholder is entitled to seek, quote, books and records for purposes of evaluating potential misconduct, wrongdoing, and things along those lines. And so under Section 220 of the Delaware Code, what a shareholder historically would do is serve a demand for books and records with a stated purpose. In other words, stating what that purpose of seeking the books and records are, and the shareholder has to establish that they are indeed a shareholder in the company. Companies, in turn, are required to respond within 5 days. And so this has been used as a tool to investigate potential claims for breaches of fiduciary duty, for example. And these can be brought, whether it's derivative or brought as a class or direct case. And so what SB 21 did is it tightened the reins on what a shareholder has to show, for example. So books and records now have to be stated with a heightened particularity in terms of the type of records, what the conduct is. And in addition, what SB 21 also did is sort of remove some of the flexibility that the Chancery Court had in terms of deciding what books and records a shareholder could obtain in a contested situation. And I can tell you from cases we handle, from cases Jeremy handles, these are often highly negotiated, very contested negotiations that go on, and I'm sure, Roger, you would agree, in terms of what documents will be turned over. Typically, a shareholder will get, and this is sort of pre-SB 21, corporate books and records get minutes and other documents that are board packets and the like. But also, what oftentimes shareholders would also get are communications. And one might say, why are communications, whether they're email, memos, or other things, why are these important? Because as a practical matter, board minutes and documents like that are scrubbed. They're sanitized. They're reviewed by the lawyers, which it's corporate lawyers doing their job, so to speak. But in doing so, one does not really often see the actual deliberations that go into making certain decisions on behalf of the company. And so what SB 21 has done is, in a sense, remove some of the ability of Delaware courts of chancery to fashion broader relief, because in the situation where a company before would either refuse to turn over books and records or would produce overly narrow documents, what a shareholder could do is file a claim, file an enforcement action, if you will, in the Court of Chancery to get those books and records that were missing. Now, what the SB 21 has done is basically said, shareholder, you only get the general minutes, certain general documents. You cannot really get anything like communications and the like unless you show a compelling need. And so that's another sort of tightening and elimination of shareholder rights in terms of the ability to go into court, because there are quite a few cases that have where courts have ruled and have given shareholders the ability to get those documents. And I can think of one case, for example. This was the derivative case that was filed against Boeing in Delaware State Court, stemming from the 737 MAX crashes. And there, one of the plaintiffs' counsel did bring a books and records action to compel Boeing to turn over what were very valuable documents in establishing really the defendant's breach of fiduciary duty and enabling shareholders to get past what's called the demand futility burden in order to go forward, step into the shoes of the company and litigate the case. And so with this tightening of what shareholders by now statute can get, it makes it a lot harder. I think two other things I'll say very quickly that SB 21 also did, and that has to do with confidentiality orders, protective orders, and agreements that companies can now get by way of statute. I'm going to come back to this in a minute, as well as, in addition to that, the ability to say anything that a company produces to a shareholder as part of the books and records demand, well, if that shareholder goes ahead and files a derivative action. And I am here to tell you, not in every case does a derivative action necessarily follow a books and records investigation. There are occasions where firms will say, based on what we see, we don't think there's a good claim here. We think, we're not going to proceed. That's more the exception, but it does happen. And so what SB 21 does is it says anything that the company produces is now automatically incorporated into a complaint that's filed. Now, I said I'd put sort of a pin in that. I will tell you, as a practical matter, in my opinion, those two provisions, both the confidentiality and the incorporation into a complaint of any materials turned over, really hasn't changed what in practice happened anyway. Because companies, as part of turning over documents, have always traditionally required plaintiff's counsel to sign confidentiality agreements in getting those documents, and generally always attempts to insert into the record at the motion to dismiss stage, so that the full full catch, if you will, of documents that they produced. So those are some of my thoughts, at least as far as Delaware SB 21 goes.
Thank you, Carol. And so then, we have here a global crowd, and we're really seeing now how shareholder litigation is really becoming globalized. There are litigations in the Netherlands, there are litigations right here in the UK, and not only are has shareholder litigation been exported, but also the question is how are the U.S. courts treating international securities? It's clear that if you purchase on a U.S. exchange, after Supreme Court precedent Morrison, those securities are covered by the federal securities laws. Let's say you purchase a bond on an international exchange. Does it belong in Europe? Can it go in the United States? And there's been a lot of litigation about this and a lot of confusion, quite frankly. Matt, first of all, what are you seeing internationally, and how are you seeing some of the international scope of securities impact U.S. litigation?
Yeah, so I have seen, I'd say, maybe a small uptick in cases that I'm working on that are filed outside of the U.S. So I'm working on some cases in Canada where they seek to represent both U.S. and Canadian investors who traded the stock in Canada, and there sometimes might be parallel litigation still going on in the U.S. on those cases. In terms of Morrison, there's definitely been a number of fights on those sort of territorial issues. I think the court laid forward a sort of a test that allows plaintiffs to attempt to establish that those securities still fall under the U.S. jurisdiction. So we have had cases involving securities that can still trade outside of the U.S., but they can trace it back to some sort of nexus that brings it under U.S. law. So we are seeing...
How is that done typically? How would you... If it's not traded on a U.S. exchange, how can you show a bond is traceable to the U.S.?
Yeah, so there are experts who will go through a tracing exercise that can actually trace the custody back to a U.S. nexus in terms of the broker where they've originated the trade, particularly for securities that are sponsored by the company itself. So it becomes more difficult when you've got like an over-the-counter traded ADR for a foreign company. Those are much more challenging. But if it's a sponsored security that's traded on the New York Stock Exchange and ADR or an ADS, then it's much more straightforward and much easier. So we are seeing, I think, an uptick in that. But I'd say relatively small, in terms of the historical average. I don't know if you, Carol, if you've seen...
Roger, what do you, I think that Petrobras had a parallel Netherlands case. I don't know whatever happened to that one. There was also parallel Bovespa traded action. I don't, but how really, the international scope of these cases has, first of all, shown the differences in the U.S. system versus international. A and B, I think, has complicated settlements in the U.S. As well. So maybe give me your perspective.
Yeah, well, it's an interesting question, an interesting set of issues because, in the Petrobras case, you had included Bovespa traded shares that were purchased by Brazilian or anyone, but who bought them on the Bovespa. It ended up that those claims were dismissed because Petrobras's bylaws required that those claims be arbitrated in Brazil.
Speaking of which,
and so we were successful with that argument. Likewise, Petrobras was successful in making that same argument in the Netherlands because those claims ended up being brought in the stichting that proceeded in the Netherlands case. That case is still going on. It's on appeal now. Some claims were dismissed. There are some claims where the claimant succeeded on liability, but it continues to go forward. But you do have a situation there where we had the settlement in the U.S. We tried to define that settlement class as broadly as possible and included, bonds. It included releases from every investor who had at least one security that was included within the U.S. settlement, and they then were releasing claims as to all other Petrobras securities that they purchased. So we tried to get as much kind of global relief as we could. The enforceability of those provisions sort of is at issue in the Netherlands ultimately. in trying to define who's still in the Dutch class. But the other point you raise is where there's a claim, that proceeds in the U.S. and but you have the U.S. securities claims, but then also like Israeli securities claims or UK securities claims that are either through supplemental jurisdiction or because there's diversity jurisdiction, and that creates an interesting issue, right? Because there are bases to try to dismiss those on forum nonconvenience or other grounds in the U.S. case, but if there's going to be a settlement, maybe there's a way to wrap all of it together up and get global relief, and to avoid the situation of Petrobras with the Dutch claims continuing to go forward even after the U.S. settlement. So I think there's a strategic question that needs to be answered. And Matt, there's also a question of like, well, how do you calculate the damages for the foreign securities? Do you look to foreign law or do you use U.S. principles? I think that's an area that's a little unclear.
Yeah, at least with the cases that I referenced in Canada, there are different calculations that are very similar to what we have, but like the PSLRA 90-day look-back cap, for example, in some of the Canadian cases, it's more of like a 10-day look-back, and then shares that are never sold are subject to slight differences. So we do have to change the models when we're estimating aggregate level damages. We do have to update those a little bit, but yeah, outside of Canada, if you have very different rules, then that could be a more significant impact, I think.
You brought up, over-the-counter stocks. And that was an issue that we encountered, in over-the-counter ADRs that we encountered in the Bayer Securities case, where the stock traded the ADRs traded over the counter. And so one of the issues that the defendants argued was that these were in fact extraterritorial transactions because an ADR is ultimately based on an underlying share of German stock, which traded on the Frankfurt Exchange. And so that was something that was very heavily litigated. We had quite a few experts on the case, including an expert who specialized just in that very issue. And what that case sort of came down to is you had about 87% of the ADRs were trading here in the US over the counter because they were existing shares. But then there was about 13% of the shares which were newly issued ADRs. And so the question became, really, are these two separate transactions, a transaction where the broker goes out, acquires the acquires the stock, takes it to the depository institution, which then in turn issues the ADR, which ends up in the hands of the investor. So is it two transactions, or what Bayer argued was that it was all part of one transaction? And so we were able to show that, in fact, they are two separate transactions, and the court agreed and ruled that newly issued ADRs by Bayer were, in fact, covered by the federal securities laws. So over-the-counter transactions, ADRs, sometimes can lead to more complicated issues unless they trade, for example, on the New York Stock Exchange, and they already exist.
Yeah, I mean, can I just make one other comment? Because so this is a conference about class actions. The other question is, like, if you have foreign securities, do you apply Rule 23 in certifying a class, or? And I have never reached that issue in a case, honestly. But both within the case itself, when at the class certification stage, but if you settle.
If you're applying foreign law, what is a foreign law?
And can you settle on a class-wide basis?
Foreign law versus procedural.
Precisely.
There's a lot of questions about that. Yeah,
and if you settle under Rule 23 on a class-wide basis, both the U.S. securities and the foreign ones, does that get challenged in another court as to whether it's enforceable?
Yeah. In the Perigo case where we did a class, it was the first foreign security traded class since Morrison. There was a rule in Israel that said, when it's dual listed, U.S. law applies. So that was what made it very easy. So then the courts there was a lot of fighting back and forth, but the courts ultimately accepted that because they accepted U.S. substantive and essentially really procedural law. The court would accept supplemental jurisdiction. What would happen if it was like a Japanese traded security or a UK? I think it's a very good question. We had supplemental jurisdiction also in the for the London Stock Exchange purchasers in the BP case, and there was individual actions. So, definitely complicated stuff. But let's hear from the audience. Any questions if we have? No? Well, just a round of applause then, please. Thank you to our panelists.